No, I think we've got about everyone, so I'll go ahead and kick it off. But thanks for everyone for joining our Houston Young Lawyers Foundation CLE series. This is something that we retooled a little bit this year based on feedback from our fellows, to really be something that's practice specific and that can help our membership. So our fellows do get free CLE with your on-time fellows payments if you have not made yours or you are unsure or would like to become a life fellow this year. You can reach out to myself or Lucy, but it's something that we have really decided is important for us to talk about things that are practice specific. For those of us who are maybe new to the foundation or listening to this after, the Houston Young Lawyers Foundation is a 501c3 grant-based organization that funds local Houston charities. We fund these charities through our events and fundraising. So if you paid a little bit for your CLE as a non-fellow, we'd love to have you as a fellow, but we also appreciate your support. We have events coming up this week, and they don't know I'm going to do this, but it's one of the fun powers of being the chair is you get to make little snap decisions. But if you are on this CLE and you would like to come to our bingo tomorrow, I have gone ahead and I have entered a special bingo price for you. So our VIP tickets for dinner, drinks, and bingo are $55. But if you log on to www.hylf.org/events, you will see a ticket that you can buy as the CLE ticket special, and we have knocked $20 off. So you'll get your CLE basically reimbursed, and I'm gonna disable it after this, and it's eligible for people who are attending the CLE. So we would love to have you. We have some seats left. We have two of our fantastic trustees and a friend of the foundation that are speaking today. Ciara Perritano is with Winstead, Austin Muck is with Bryant Consultants, and Lamar DeLong was voluntold by our immediate past chair, Michael Clinton with Zell & Associates, to fill in for him. So I'm going to turn it over and let them talk on corporate representatives from the both sides and the inside counsel perspective. So thanks to everyone.
Okay. Hi, everybody. Thank you for joining us. As Samantha-Ann said, we have a CLE series in HYLF and a lot of good, valuable content. So today we're going to talk about corporate representatives. I have a PowerPoint. Let me figure out how to share that real quick. Sorry, I could have done that while Samantha-Ann was talking, but I did not. Okay. Okay. Can everybody see I think I'm on the wrong screen. I apologize. All right. Do you guys see the screen that's the first PowerPoint slide, or do you see the screen that has the next slide on it?
We see the whole PowerPoint where you can see all the 6 slides, upcoming slides on the left side.
Okay. Well, let me redo this real quick. Sorry about that, guys. You know, HYLF is a teaching organization, and I am appreciative.
Ciara will be chairing our new technology committee next year.
Okay. Well, that won't be getting very far. So, all right. A guide to corporate representatives. I'm going to do a brief overview of what a corporate representative is, and then discuss depositions and get a little more nuanced. I also put a fun little game in the PowerPoint because I was going through this. It is kind of a dry topic. So I wanted to really engage everybody and also spice up my PowerPoint. So I have included some of my favorite movies and shows in the PowerPoint. If you are the first person to enter the name of the movie or show in the PowerPoint, you'll get a point and an extra point if you can name the characters. And then at the end, you'll get a Starbucks gift card. So, you know, spice up a dull topic. All right, what is a corporate representative? Okay, so corporate representative serves multiple purposes. They show up at the deposition to speak on behalf of the organization. This is not just for corporations. This includes partnerships, entities, limited liability companies, basically any organization, although the name is corporate representative. It covers a broad category. You really want to put a face on your organization throughout the case, especially when you're defending an organization. They answer questions on behalf of the organization, and they're the point of contact and report to the organization at trial. Depositions are covered under Federal Rule of Civil Procedure 30b-6 and Texas Rule of Civil Procedure 199.2b. FRCP 30b-6 provides explicitly that a party may name as the deponent a public or private corporation, a partnership, an association, a government agency, like I talked about, or other entity. That basically encompasses any organization. So you're not going to play fast and loose and get out of having to designate a corporate representative because your entity may not fill one of those names. Prior to designating a corporate representative, a party will send a notice. I'll cover that in a few minutes, but that is covered under the rule as well. Under Texas Rule of Civil Procedure 199.2b, it pretty much mirrors the federal rule. The only difference, interestingly, in the rule is that the Texas rule, which is very rare that the Texas rule is more specific than the federal rule, but the Texas rule takes the federal rule a step further and includes in the rule what the rep must testify to, which is matters that are known or reasonably available to the organization. I'll dive into that a little bit later, but reasonably available is something that may get people in trouble when preparing their corporate representative. So those are good touch points. All right, the notice. As many of you might be aware, before you take a corporate representative deposition, you have to send a notice to the other party. Both the federal and Texas rule require that the notice describe with reasonable particularity the matters on which the examination is requested. I've gotten notices with 100 topics. Sometimes that is insane. I'll cover that in our objections portion later. But your notice needs to be specific. When you present a corporate representative, this is a prepared deponent, unlike other witnesses who are just speaking about things within their personal knowledge or facts that they know. A corporate representative is there to be prepared and speak on behalf of the organization. The organization is not a person, so you need to specify with particularity the matters that they will be deposed on. It's not enough just to say, the rep needs to speak about all procedures. Like, you need to tell the attorney and the deponent exactly what you want them to testify to. If you don't, you may lose recourse in the court later. So, strategy. The noticing side, preparing the topics and considerations. I didn't specify this at the beginning, but Austin is in-house general counsel for consulting group that is expert witnesses and professional engineers. And Lamar is a plaintiff's attorney. Most of my work is defense, or plaintiff side to the extent that we're just seeking damages. So I thought it would be good to hear their perspective, since most of my perspective is defending depositions. So I'd ask Lamar if you have any, so on the slide, if you have any notes about what you look for when you prepare topics and considerations when preparing your case to go forward.
Sure. Thanks, Ciara. The noticing a corporate rep deposition kind of depends on what the case is and where you're at in the case. So just, you can ask for a corporate representative for any topic that you want to, get answers that bind the company on. I've taken corporate representative depositions on venue-related issues, but more often than not, after I get fact witnesses, as a plaintiff's attorney, we focus, at least my firm, focuses on third-party negligence cases. So the easiest example I can give is a trucking company. If you're suing you've got a commercial motor vehicle wreck, for example, you'll sue usually the driver and the company that employs that driver. And so after you get you can notice the corporate rep at any point in time, but typically what you see is you want to get the corporate rep to answer questions about their investigation, their hiring of the driver, any disciplinary records they've got. So that's kind of how I typically take corporate reps in trucking cases. I'll send a notice, kind of like the one that I've got pulled up attached. And this is, well, I don't know if I can share at this point, but I've got templates if anybody needs to see. But ideally, what I put together is just like a set of topics that are usually about 10 topics with some subtopics within. So if I want to ask about the hiring generally of a truck, the hiring practices that the trucking company employs, I'll ask about, their hiring process, what criteria they have for screening applicants and testing applicants, so on and so forth. Same with training, review of compliance related issues, because truck drivers have to comply with their hours of service and whatnot. And if fatigue's an issue in the case, then I'll want to make sure that they have somebody, the company has somebody that is knowledgeable about the topics of that particular driver's hours of service. But, switching lanes, we also do oil field cases and we do offshore cases too. And none of those cases really fit. There's not a common theme, much like a car accident case. So you kind of have to, get into the facts of your case and figure out what you want the company to answer questions about on a, case by case basis.
And to expand on that a little bit of what Lamar had said, when talking about getting into the specifics, you also need to do that on the defense side. If a plaintiff sends a notice asking for policies and procedures related to, make it easy, a slip and fall, you need to go look and find those policies and procedures and figure out what exactly is relevant to the case and be prepared to object to anything outside the scope of what's relevant. And we'll talk about that in a little bit. But going back to strategy, as a defense attorney or any, plaintiffs also have corporate reps. So just the defending party for the representative deposition, considerations to think about are responding and objecting to the notice. You need to do that fairly quickly because you need to get your objections or protective order on file. There's a lot that goes on. You also need to figure out what witnesses you're going to prepare and select. And you might need a contingency plan. Say you have 10 topics and you're objecting to 5. Well, the court might not sustain your objections or might not grant your protective order. So in the event that you do have to present somebody to testify on those 5 topics, you need to have somebody in mind. You also need to notify the client immediately or as soon as possible so that they can start gathering relevant documents. You do have duties when preparing these representatives, so you need to tell the client as soon as possible because that's where you're going to get your documents from. And I'll go over those duties or responsibilities in a few minutes.
Yeah, and Ciara, you mind if I jump in real quick there? I'm sorry. And as Ciara mentioned, I'm in-house counsel with an engineering firm called Bryant Consultants. And when you're thinking about selecting the witness from the really the defense or the plaintiff side, but you're talking with your client about selecting the witness, or if you're in-house, you're kind of just trying to determine who the right person to select and be that witness. I mean, at my firm, we're a smaller company, so it makes it a little bit easier. But at larger companies, there's certainly things you want to consider. I mean, a 30B6 witness is kind of like an expert witness in the sense that you can choose who you want to represent and tell your story, right? So, a fact witness, whoever was there is the person gonna be the witness. A 30B6 witness, you can choose who's going to represent the company. And so, you want someone obviously who is well-spoken, confident, able to understand the issues and able to communicate on behalf of your company. As a corporate rep, you got to remember, a lot of times, like in the cases Lamar was referencing, you're talking about a plaintiff, versus a big company, right? And that can be a jury may be persuaded by, wanting to help out the little guy. So you got to make sure you're finding someone who also is a little bit more empathetic than your typical witness you would want otherwise, right? You want that person to be likable. Obviously, you want all your witnesses to be likable, but You almost got to have a sort of empathy that's displayed from a corporate rep that you wouldn't necessarily want when you're selecting your expert, right? So those are some important things to consider. Another thing particularly at a bigger company is, you want to select someone, or you want to work with the company so that they're picking someone that's not going to disrupt their flow of business, right? I mean, if you're having to pull out a supervisor or a project manager that maybe they're a service organization and they really depend on that person being there to actually earn revenue, maybe you pick someone who would be just as good, but is a back office, like an in-house counsel or someone else who is not going to disrupt their flow of revenue as a company. So that's another consideration you want to have. And back when I was practicing, before I went in house, I was in an instance where we had we were representing a small company and they got noticed for a 30B6, and we had to present the president. Now, the president was like intimately familiar with all of the facts of the case. And so there was really like no distinction between where he served as a corporate rep and where he served as a fact witness. And, I thought for efficiency, we'll just kind of combine them and do them as one, but that turned out to be a nightmare. In hindsight, would not have done that. I think what you really want to do is find someone who already has a general understanding of the corporate structure and maybe the relevant compliance information, but doesn't know the intimate details of the facts at that case. So that way, they can, during the deposition, they start getting asked questions that probably go a little bit more too specific than what the 30B6 is meant for. They can say, look, I don't know, you're going to have to ask someone who was actually on site or actually, familiar with the specifics of this industry, right? I'm serving as this corporate rep for these broader topics. So those are things you probably want to consider when you are choosing your witness.
And just to piggyback off of what Austin just said, a lot of times in these corporate rep depositions that I take, I get the answer, I don't know. Right. And there's not objections to the specific topic that I've noticed that I'm expecting the witness to be prepared and knowledgeable about. And so, I don't typically move for sanctions, but that is a remedy that I see a lot of my colleagues on the plaintiff's bar doing, is if, a corporate rep is not prepared to give testimony on, like, say it's a death case, right? And they just say, I don't know, you'll have to talk to that person. Well, I'm not talking to that person. You're the person that's been designated as the corporate representative to give binding testimony on this company. So, to what Austin, said, you want to have somebody, you want to have a not just a simple, I don't know type witness that's going to give those answers. That's what I would do if I was on the defense side. Is I would
I was going to say, maybe you do.
I would have, a good excuse as to why they don't know certain areas of questions that they're supposed to be designated for, just to prevent any blowback from guys like me,
That's fair.
And I will say, I think I am covering this in another slide, but to the extent your witness doesn't know something, I have been in depositions where I have told them you need to find out the answer on a break, or we've requested from the other side, like, hey, can we take a 10-minute break so they can call, X to get the answer to this. To consider with that, though, as soon as they come back and tell you the answer, the follow-up question is going to be, who did you call? And that person is the next deposition notice that's going out. So to the extent that we do need to call a lifeline, it's usually somebody that is already disclosed or their deposition has already been taken, because it kind of is a team effort, especially when you're like reconstructing an accident or rebuilding what happened. I think it's fine to call a fact witness or call somebody that's already been disclosed. So you just need to make a strategy decision there, like, hey, do we potentially want to disclose an extra person? Also, if you say you don't know in the deposition and there is no lifeline called, you need to immediately change your answer, or you need to immediately alert the other side if new information comes up that now you do know. Otherwise, as Lamar said, that could be sanctionable. Testimony, if it's helpful to you, could be struck at trial. So those are things that you want to, really make sure your witness knows that that they don't get to say, I don't know, you know, if they genuinely don't know, okay, but that's not this kind of deposition. All right, objections. So these are topic objections for the notice. In federal court, you have to seek a protective order. The federal rules of evidence still apply to deposition topics. Just because it's a corporate rep, the federal rules of evidence don't fly out the window. I think sometimes people are like, oh, well, it's the rep, I can ask them anything. We can't. Still needs to be proportional to the needs of the case. You know, can't be into any non-privileged matter, has to be relevant. So just think about those topics when preparing your objections. The proper procedure to object to a 30B6 deposition notice is not objections, but it is seeking a protective order. Make sure you do this in federal court. That said, go ahead and draft objections because you're going to need to include them in your motion. You also have a meet and confer requirement under Rule 30B6. So this is like the rational first step in your meet and confer requirement. So I think that objections are a rational starting point here. It also helps you with your paper trail when you get in front of the judge. Judges hate discovery disputes. Federal judges especially hate discovery disputes. So, you know, to the extent that your objections are well thought out and written out, you can start that paper trail for the court. Look, Your Honor, drafted objections, sent them. Counsel wouldn't meet with me, or they would. They wouldn't limit their topic. So that's a good point. But in goal, you need a protective order in federal court. Texas, however, does not have any procedure that requires objections. There's no requirement for a protective order. Rule 192.6 says that you may move for a protective order, but you don't have to. It says the person from whom discovery is sought and any other person affected by the discovery may move within the time permitted for a response. So for a deposition, that is the time until you are presenting your witness, can object. So you can do a motion to quash or a protective order, but you don't have to. Up until 2023, there was no case law on this. In 2023, Home Depot put a corporate representative up for deposition. They served objections the night before to the notice. Plaintiff's attorney did not appreciate that. The defense attorney objected in the deposition saying, hey, we served our objections yesterday in email. Like, we're not talking about this. Went up to the Ninth Court of Appeal. The trial court also agreed with plaintiff's counsel that, hey, your objections were not sufficient. You need to get a protective order or move for court intervention. The Ninth Court of Appeals on mandamus said, no, you don't. The objection was fine because counsel objected prior to the deposition, and during the deposition, those objections were fine and permitted under Rule 193.4. The burden is on the requesting party to establish that the discovery is relevant, and the burden is on the requesting party to set those objections for a hearing if they want them to be ruled on before the deposition. So as a deposing party, if you receive objections, I would anticipate that your defending attorney is going to object to any topics. I was actually the attorney in this case, so if you have questions, it was my appeal. So if you have questions, feel free to reach out. It was exciting because it was one of the first cases in Texas that really talked about these objections at a deposition. It was a very unpleasant deposition. So lots of tips and tricks. It lasted over 6 hours.
I have a question for you, Ciara. I don't know if that's allowed on while you're doing your
yeah, go ahead.
Yeah, so if I get objections to a corporate rep topic list that I sent or notice that I sent for corporate rep, I have the depot set, let's say it's tomorrow, and I get the objections today. This rule says that I need to postpone the deposition effectively then, and then get a ruling from the trial court on those objections before we proceed on those topics.
Yes, I think that would be best practice. Well, depending on how many topics are objected to. If it's just one or two, then I would go forward with the deposition and see what you can get out of those topics. Like maybe you don't need them, but if every topic is objected to, then you probably need to get a ruling before requiring, because per the Ninth Court of Appeals, I can show up and say I objected. We're not talking about it. I will say the topics in this case were so overbroad. I'm happy to share them with anybody, but it was a workplace injury case. The topics that they wanted our reps to discuss were like every policy and procedure for the last year, including like citrus quarantining for orange trees in the garden section that had absolutely nothing to do with this like lifting incident. So it's just completely overbroad. We did in the deposition say, hey, she'll talk about, these limited things. I thought I was being reasonable. So did the Ninth Court of Appeals. So anyways, I think you just need to look at it as a case-by-case basis and decide, is it worth your time to go to the court, get objections ruled upon, especially in Harris County or a lot of state courts, it might be a few months. So if it's just a few objections, I think you just have to make a decision then and there what's worth your time or not. But if it's a big case, I'd probably seek court intervention. But, for some of the smaller corporate rep depositions, I don't think it might be necessary. But again, that's only state court. Federal court, you have to get a protective order. All right. Taking the witness, I have to ask, does anybody know what movie this is?
Okay. Vendetta?
No, I'll just tell y'all, I included it. I'm getting off topic, but one of my husband's favorite lines to quote whenever we park on level 3 at the airport. We always park on level 3 because we remember it's from Shrek when Lord Farquaad is, I don't know what he's doing, but the executioner is like, 3, pick number 3, my lord.
He's like picking his date.
Yes.
And he picks Fiona.
Yes. So I just threw this one in there because it had the word pick in it. Just trying to make it fun. All right, taking the witness. Knowledgeable does not mean most knowledgeable. Like Austin said earlier, you want somebody that's going to present well under the law, under case law. They do not have to be the most knowledgeable person in the organization. You also have to look at business disruptions and other considerations when picking a representative. Personal knowledge is not required. Per the topic, you are required to educate your witness. So they don't have to have personal knowledge. That needs to be contrasted with requirements of admitting trial testimony later. But for the deposition, they don't need to have personal knowledge. Their testimony is to the knowledge of the organization. So preparing the witness, I found this case from DC, and I thought it was this is not required under the rules, and of course you're not in DC, so it's not mandatory law in Texas, but I saw these duties that were explained by this court, and I thought that they were really helpful and basically summarize your duties to prepare a representative. The deponent has the duty of being knowledgeable on the subject matter. If they can't talk about it, don't present them. Like, that's a waste of everyone's time. It's going to tick off the other side. Each side is spending a lot of money on corporate representative depositions, so they need to be knowledgeable. The designating party is under the duty to designate more than one deponent if necessary. The rule actually says you have to designate one or more witnesses. So you do have the duty under the rule to designate one or more people if necessary. And that doesn't need to be a simultaneous notice necessarily, or a simultaneous designation rather. If you present, John to testify, and at the end of the deposition, it's clear that George is better fit to testify to 4 topics that John didn't know about, you can offer that. So before the deposition closes, I would say, hey, it's clear that he didn't know as much as we thought he did. We're going to designate a second person. And I think that's a way to kind of appease everybody. Or alternatively, when you get the notice, you can respond and say, hey, John's going to testify to 4 topics, George is going to testify to the other 4. So I don't necessarily think it needs to be simultaneous, but you can do those stacking if you want. The designating party has a duty to prepare the witness to testify on matters not only known by the deponent, but those that be known by the designating party. This is just like educate them, find out what the answers are. Don't simply get, don't simply get answers limited to what the deponent happens to know. Like, you need to investigate. The deponent can go talk to other people. You know, you need to do interviews as an attorney. I've hopped on the phone many times with a corporate representative and fact witnesses because they need to know what's going on. If the organization has a position, that position is going to be made through fact witness testimony. Again, number 4, the designating party has a duty to substitute an appropriate deponent when it's apparent that the previous deponent is unable to respond. You know, you just have a duty to supplement, essentially. All right, preparing the witness. Documents reasonably available. I read a ton of case law on this, probably the last few months because I keep having corporate rep issues come up. Reasonably available doesn't really mean reasonably. So it's kind of a big, broad investigative requirement. So I found case law that suggests that even if somebody is dead, you need to go pull their file and go through their file and investigate, find employees or coworkers who knew this person. That is considered reasonably available. This also comes up a lot when banks merge. I do a lot of finance work, and banks merge all the time. When they merge, they get rid of redundancies. So sometimes you have an entire legal group leaving during the merger. If you were trying to get policies and procedures for Bank of America, but they have been acquired by UBS, well, UBS has access to, I'm just making up these banks, by the way. UBS will likely have access to Bank of America's old procedures and policies. I think they're required to keep them for a statutory amount of time. So you need to get with the new general counsel and have them go find Bank of America's old documents. Just because a merger happened doesn't mean that, you know, they're off the hook. That entity doesn't exist anymore. You need to go find the things. Includes documents within the control of the organization despite age. That goes to my merger example. You know, if there's old documents, you got to look for them. You need to have a paper trail. You need to email your client. You need to cover yourself with counsel, and you need to cover your client. The court asks you, what did your client do to look for these things? You need to keep a paper trail, because I guarantee you the judge is going to say, go look again, or have somebody sign an affidavit that said that you reasonably looked. These are all the places that you looked. I had a case a few years ago where I physically drove to a location in LaPorte, Texas, and looked through file cabinets in my tennis shoes in a warehouse to find something, and we actually found it. But the judge, it was Judge Tipton, was like, you need to send a lawyer out there and dig through the file cabinet. So deponent is not required to be an expert witness. They're not an expert. They just need to be knowledgeable. The deponent is required to know the factual basis underlying theories, but they don't need to explain legal theories. They're not a lawyer. Oftentimes, attorneys will ask, well, do you know why your company is, you know, pleading this affirmative defense? Like, you can just say, no, we're not talking about that. This isn't a deposition on legal theories, and move on. Also, when you prepare the witness, go over all of the documents with them. Go through all the documents, go through other witness testimony. Like, they're speaking on behalf of the organization. I don't think you can prepare too much for a corporate representative deposition. And this is a small case, like, obviously, like, balance, you know, your client's funds and needs. But for bigger cases, like, they need to go through all the documents. You need to go through the documents with them. You need to ask them questions that you think the other side will ask. You know, they might know the knowledge of what's in the documents, but they might not know how that applies at a deposition, or what kind of questions might come out. So just assume they don't know nothing. A lot of organizations have corporate representatives as a job. I don't know why anybody would take that job. That sounds really stressful. But just assume that your witness doesn't know anything. Even if they have 1 or 2 depositions under their belt, every deposition is different. They need to understand the case, and they need to be able to free think of why questions are being asked. So without divulging too much of my strategy, since Lamar is on the call, I'll move on. But
Well, Ciara, I was gonna kind of second that comment about, I always appreciate it if outside counsel it doesn't assume anything and over explains, right? Be to the point, tell us where the weakness areas are, right? Tell us the pitfalls, potential pitfalls, name them exactly as they are, and then give enough time to actually prepare, and then spend the actual time to do the preparation, right? And so, and another thing, like I'm looking at Elle Woods over here, and she says, I feel comfortable using legal jargon in everyday life. And that may be fine for her, but for your corporate rep, you probably don't want them using legal jargon. You want them to be able to communicate all this stuff in a very plain spoken way. As we talked about earlier, you want them to be relatable in the face of the company as well. So, um, you know, I think it's important not just to go through if an outside counsel is working with in-house counsel or their corporate rep, not just go through the documents and practice their responses to questions on the documents themselves and practice, talking about what their answer could be for all the different topics. I think it's also very important that you walk through the theories of the case at hand with them and say, okay, we have these claims, like here's generally what our story is. They have these claims, here's generally what their story is. They're going to move for summary judgment on this issue. To prove that, they're going to try to say X, Y, and Z, right? And that didn't happen. So here's how we're going to kind of phrase these things to help us understand that, right? And get down to that kind of specific level so that the person testifying, just kind of inherently then builds this knowledge base of, okay, here's where I'm fitting in the story. I'm going to tell the company's story. I'm going to tell the truth, but the different words I use to describe things do matter. Like, it's important to get the phraseology right, and you can only get that right if you are continually talking about it and your outside counsel is continuing to ask you questions about it, right? And so, like for instance, I mean, a simple thing. If I'm being deposed, I don't want to say Bryant Consultants policy is blah blah blah. I'm going to say our policy, right? I'm gonna personalize it. I'm going to make it. We're not this company. We're a collection of humans, right?
Yeah, I think that's a really good point. And, we always tell, or I like to tell representatives, like, hey, these people are looking at you. That's why I put the Wizard of Oz on the front page, because they look at it like Oz, companies as this mysterious place with their headquarters somewhere. And obviously,
Right.
since I represented Home Depot, we would always get, well, they're just a big bad company in Atlanta. And I'm like, hey, look, you need to tell them, I'm a store manager. I've been working here 20 years. Like, this is my livelihood. This is my community. My kids go to Kingwood High School, XYZ. Like, really humanize the company because it's people that work there. It's not robots in Atlanta that are here. So
Well,
I think
you really did your research here, because I actually graduated from Kingwood High School, so.
Oh, really?
Yeah,
I did. I researched to prepare. Yes. So I did not know that. I'm not a creative.
I know that's funny.
Yes, but you want to humanize them. You want to, really get the reps on the same page. And the only way you can do that is practice and communication. And I have some comments about communication, but they are saved for 2 slides from now. So, okay, the effect of testimony. So I've been following the Blake Lively drama, so wanted to throw her in here. Her new complaint just came out, filed at 11:59 last night. Anyways, testimony elicited from a 30B6 rep, and when I say 30B6, I'm only talking about federal court right now. So testimony elicited from the 30B6 rep is knowledge of the company, not individual deponent knowledge. And that goes back to what Austin said about mixing fact and corporate rep testimony. Like, you really need to draw a line on, are you testifying on behalf of the company, or is this your personal knowledge? So there is a split in the courts about whether the deposition is binding. There's a split in the federal federal courts. Some courts have said the testimony is not binding. Other courts have said it is binding. At the end of the day, though, it's a credibility issue. A jury is, regardless of whether it's binding or not, a jury is not going to like different corporate officers or employees testifying to different things. So I think technically it doesn't really matter if it's binding. It might in a nuance for emotion, but at the end of the day, you know, you're pretty much bound to the testimony. There's case law that says that you need to have a very good reason to change your testimony later. Supplement any I don't know testimony as soon as possible. Like if you find out a week after the deposition that, you know, you just found a new document, supplement it ASAP, clear the record, because if it comes out months down the road, that's not going to look good for you. Texas is home of entirely undeveloped case law. There is no case law on the binding effects of corporate representative testimony that I have found. If you find any case law, please send it to me. I dealt with this case this issue a few months ago. We inherited a case from a different law firm. The corporate representative knew nothing. We found somebody that did know things that we wanted to present at trial. To our collective knowledge, the best you can do is amending an errata sheet and supplementing it ASAP. Lamar also had mentioned that he has seen this practice recently. Not to be crass, but it really pisses people off. Amending an errata sheet just really takes people off. Sometimes though, like in my scenario, that's all you can do. What I think the courts will do is say, hey, you know, we can open up the deposition again. You can take their depo again. It's not going to look credible in front of a jury. You know, somebody said a year ago that your client has $0 in damages, and then now you have this new guy coming in saying, you know, we have $300,000 in damages, but it just doesn't look credible. Do you have anything to add to that, Lamar?
Yeah, no, what I would say is if I get an errata sheet that has a bunch of changes from to answers to questions that were very clear, like just substantively are different. If he said yes, and now the answer is no, and there's an explanation, and I go and reopen the deposition, you better believe any plaintiff attorney is going to grill the next witness if it's the same guy and it's a clear question and answer. I mean, what did you not understand about that question at the time that I posed it, sir? You know, and it's gonna make things really difficult, I would think, for the representative that is now changing their answer. So I would just be wary before doing that. Some folks do it, you know, unabashedly, but I would say only change answers when there's a legitimate, you know, misunderstanding there. That'd be my 2 cents. I don't know.
Yeah, well, and this goes back to preparing the witness too. Like they need to know this is not a conversation. Like you are under oath. This has the same effect as it does in court, and whatever you said is on paper. The jury's going to hear it. So you need to make sure your witness understands that, and you need to drill it home. All right, documents. If you want documents before the deposition, if you're requesting the deposition, you need to send a request for production and your 30B6 notice. I put 30B2. I think maybe that's the rule. I'm not sure why I put that. Maybe it's the rule about RFPs. I don't think it is. Anyways, as a practice tip, make sure you send this well in advance. If you're requesting that a corporate rep bring documents with them to the deposition, that doesn't really help you because you haven't had a chance as the questioning attorney to review the documents. So even though they have to produce things in 30 days, like maybe send your RFP 60 days in advance of the deposition. That way you can, you know, review documents, make questions based on those documents. So documents that you are having your corporate representative review, traditionally, these should be things that you have produced in discovery, like their policies and procedures or anything referenced in the topic. That said, they may review work product, but just be wary that work product may be discoverable under Federal Rule of Evidence 612. That is the writing to refresh memory rule. These writings can sometimes be discoverable. So if a witness says, oh, I looked at my attorney's notes to refresh my memory on XYZ, well, now you've got an issue and the attorney might have to produce those documents. A lot of times courts will do an in-camera review and any portion related to the witness testimony will be disclosed, but maybe not other attorney notes. But just be wary if you prepare anything for your witness in writing, it might be discoverable. Corporate reps can also authenticate some documents under Federal Rule of Evidence 901B, which is just our authentication rules. Texas, same thing. If the deposition notice seeks production of documents, this isn't like a subpoena juice tecum. It falls under the RFP rule, so you need to give 30 days notice for that. Also, I had a note for my last slide, but it's a note related to Apex depositions. Corporate reps are sometimes the first step in getting an Apex deposition. If you get a corporate rep deposition, it's just not covering things, like topics are not being answered sufficiently, you can use that as a step to go get an Apex deposition compelled. Like, you know, look, judge, we took as many steps as we could to get this information, but sometimes you just need an Apex deposition. So that's another consideration. All right, this is my last slide. Luckily, we ran out of time to go deep into trial because the case law is so heavy that you could have a separate CLE on corporate representatives at trial. 30B6 does not exist at trial. 30B6 is a pretrial deposition rule. So like once you get to trial, stop using that term. At trial, you want your corporate rep to sit at the counsel table with you. You want them to look engaged. You want them to look like they care. If they don't, that could be the end of your case. The jury is being called there. They have to stay there for weeks sometimes. The company needs to send somebody just as attentive. There's strategy considerations with this, like everything I just said. 30B6 is not a trial term. Corporate representatives are exempt from the rule. There are scenarios when they can be called as a witness. Sometimes they won't be if they're just an appearance representative. If they are called as a witness, A, they have to have been on somebody's witness list beforehand. B, there are strategy considerations. Even though that they don't have to be sequestered, they can be put on the stand prior to plaintiff's other witnesses. A good defense attorney, however, will say the plaintiff didn't have this appearance rep on their witness list, so we're not putting them up. Anyways, there's a whole slew of federal rules of evidence that you can get into there. The one thing I did want to note on trial is Federal Rule of Civil Procedure 32A3 says that a deposition of a party agent or designee can be used for any reason whatsoever at trial. So although there's not a ton of trial rules with corporate representatives, their deposition is fair game. So they can show their deposition to fact witnesses. There's a lot of federal rule of evidence considerations to the extent that witnesses have to have personal knowledge. As we talked about, a corporate rep doesn't necessarily have personal knowledge. So there are a lot of evidentiary issues there. That said, you can use the deposition for any reason, and I think that that is a way to circumvent some of those other hurdles, those evidentiary hurdles. So that is our presentation. Does anybody have any questions?
Hey, Ciara, and Austin and Lamar, thank you all so much. I had a quick question about general counsels. I know Austin's a GC, and I know Samantha-Ann's been a GC as well. Is there, I mean, I imagine, you know, technically a GC could be a corporate rep. I know it'd be, you know, advised against because of conflict of interest, and, you know, it'd lead to the GC, you know, not being able to advise the company throughout the trial. But I mean, is there any reason why a GC would be asked to be a corporate rep? I guess just for a very sort of limited scope of.
So I'll speak for me personally. I have not actually been a corporate rep, but I talked to Samantha-Ann, and she has been a bunch. So
Okay.
you know, I don't. I think it probably just depends on a case by case basis, right?
Right. I was just curious. Yeah.
It's
Yeah, I think you have to draw a line. I'll let Samantha-Ann talk about it, but I think you just have to be careful about privilege issues at some point there.
Right. That's what I was thinking.
it's definitely a hard line to walk. It's and I didn't interrupt on the program because they were doing such a good job, but being the corporate rep as a corporate counsel is hard. Because you know probably a lot more than the case and you're allowed to say. It's one of the reasons that I strategize so much with my outside counsel of, what are we trying to avoid? And I think that that's a very valid question to ask. 90% of the cases that you corporate rep for is not going to be something that is so overt, like smoking guns happen on SVU. They don't happen in real life for the most part. But there are things that you want to avoid and you want to kind of stay away from. And so in strategizing about that, but it's a case by case strategic decision for sure. But I think that you get a little bit of the removal from the facts as corporate counsel, which is really helpful because you weren't 99% of the time you weren't involved in whatever the claim was.
Right. Thank you.
Any other questions? I was really nervous we would get like some crazy like trial questions, so nobody asked one. But if there are any other questions, let me know. All right. I think the winner was Nadia for the game. So she got those little bonus points with her. Nadia is just so good at everything, so not surprised. I'll send you a Starbucks gift card to your work email. The CLE number is in the chat at the top. I'll repost it. You need to report it yourself, I think, right, Lucy? I don't know, Lucy.
Yes, report it yourself.
Yes.
Okay, so go to the State Bar website and type that number in. If you lose it, just email me or Lucy and we'll get it to you. But thank y'all for coming. Bingo is tomorrow night. What else?
Link is in the chat if you'd like to buy discounted tickets. They'll be up for the next 2 hours. Thanks to Ciara, Austin, and Lamar for leading the CLE today. We appreciate y'all so much.
Absolutely. I have one more self-serving plug. On March 6th, the Moms Committee is doing a private showing at the Contemporary Craft Museum. You don't have to be a mom to come. You don't even need to be a woman to come. It's only been women, but if you are not one and want to come, feel free. And then we also have a coffee date on March 27th. So feel free to email me for either of those items. But thank you all.
Thank you for having us.
Thanks, everyone.
Thank you.
Okay.
Guys.
Bye, guys. I'm leaving.